The Supreme Court resoundingly affirms the Second Amendment. Good evening, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. And folks, today, this one's a doozy. Today, the Supreme Court struck down a 109-year-old gun law, the worst in the country, and struck terror in the hearts of left-wing bullies across the land. The president, the governor of New York State, and the mayor of New York City all condemn the ruling. And if this particular troika condemns something, it must be good. We're going to talk about just how good it is. Before I begin, I want to shout out to the sponsor of this channel, which is Conservative News and Views, link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom of that link. Lots of good merchandise there, including this t-shirt I'm wearing, Rhino Hunting. All right, ladies and gentlemen, get your party hats on and blow your noisemakers. Noisemakers, nothing. This is good for fireworks. First, a Supreme Court update. The Supreme Court released 4 opinions today, including the decision in New York State Rifle and Pistol Association versus Bruin. In the other 3, the court held that North Carolina legislative leaders may intervene in a lawsuit challenging the state's new voter ID law. The North Carolina NAACP is trying to sue away voter ID. The governor, attorney general, and board of elections are defending the law only half-heartedly. Hence, the motions by the North Carolina legislative leaders to intervene. Berger versus North Carolina State Conference of the NAACP. Next, a prisoner asking for a substitute method of execution for which state law does not currently provide may still sue under Title 42 U.S. Code Section 1983 for unconstitutional maltreatment. Nance versus Ward. And last, failure to Mirandize a suspect doesn't automatically make an interrogator liable. Vega versus Tico. This whittles down the number of cases remaining to decide to 9, including Dobbs versus Jackson Women's Health Organization. The court has 1 opinion issuance day tomorrow and will likely create 1 or 2 opinion issuance days next week. So much for the coming attractions trailers. Now comes the feature presentation. I have left a link in the description of the opinion from a source that will never lose it. Clarence Thomas, the senior member of court, delivered the controlling opinion. At issue in New York State requiring those who apply for a concealed carry license to demonstrate a proper cause. In other words, the applicant must show that he is a direct target or otherwise needs to defend himself with a gun more than the average Joe or Josephine. The New York State Rifle and Pistol Association sued on behalf of 2 average Joes. Why, they asked, should it matter whether one could show that he was a special target or not? In fact, such targeting is most effective when the target doesn't know it. In short, New York's law violates the Second Amendment. It also breaks the 14th Amendment, which effectively means no state may violate the Federal Bill of Rights. The district court denied their claim and the Second Circuit Court of Appeals affirmed the lower court. The Second Circuit relied on its own precedent of Kachalski versus City of Westchester, which upheld the proper cause standard. Today, the Supreme Court said no. The Second Circuit was wrong before and is just as wrong today. Justice Thomas identifies 6 states and the District of Columbia that issue licenses to carry firearms only at police discretion. These may issue states are California, Hawaii, Maryland, Massachusetts, New Jersey, and New York. Furthermore, Justice Thomas cited an article in PolitiFact listing 25 constitutional carry states. I've left a link in the description to that article as well. Now, two definitions. Shall issue means the authorities must issue a permit after someone satisfies some objective, verifiable criteria that is safe for everybody. May issue means the authorities get to pick and choose. The D.C. may issue regime has been under permanent injunction since 2017. Various circuit courts of appeals have upheld all the rest, but perhaps they may do so no longer. Thomas based a solid finding for the Second Amendment on two recent precedents. One of them is District of Columbia versus Heller from 2008. The other is McDonald versus City of Chicago, 2010. Those two precedents established a Second Amendment right to carry a gun for self-defense in the home. Now the court recognizes a Second Amendment right to carry a gun for self-defense outside the home. This is a right, not a privilege of law enforcement, military, very important persons, or special targets. Perhaps by way of showing standing, Thomas emphasizes that if a licensing officer denies a permit, there is little or nothing an applicant can do about it. Brandon Koch and Robert Nash are two average Joes living not in New York City but in Rensselaer County. They also belong to the New York State Rifle and Pistol Association, which is why that body is interested. The details of their travails with the licensing officer in Rensselaer County are of little interest, but this brazen declaration by the officer should interest everyone. He asserts that the purpose of restrictions on a carry license is, and I quote, to prohibit someone from carrying concealed in any location typically open to and frequented by the general public, close quote. And if you read the opinion, you'll find that that phrase, any location, printed there, is in big, quivering capital letters. Now, ever since the Supreme Court in Heller held that the Second Amendment was an individual right, not a right of the people as a body, various courts of appeals have tried to dance around the issue, dance around the Second Amendment. Thomas calls this the two-step approach, the two-step framework. Step one is to review the history of gun laws. Step two looks at what extra burden a law puts on the Second Amendment as those courts understand it. No more, says Thomas. The Second Amendment, he says, presumptively protects the keeping and bearing of arms. So the history, and only the history, may govern. The biggest problem for the courts of appeals is that they have assumed that the Second Amendment right to keep and bear arms applies in the home and only in the home. Wrong, says Thomas. In his extensive survey of the history, he clearly shows that the Second Amendment codifies a right Americans have always had. Now, how does the Second Amendment protect only those weapons in use when nor does the Second Amendment protect only those weapons in use when James Madison wrote it. Here, Thomas seems to have heard the same thing I keep hearing anytime I try to argue with a gun grabber. Back then, they didn't have such a weapon. That doesn't matter. To quote the Heller case, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Now, before you start scratching your heads and asking me, prima what? No, it isn't prima donna. Prima facie is Latin for at first view. It means the evidence is enough to support a given verdict unless someone can contradict or rebut it. Let's take a little break here because I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well that even the administrators can't see it. So, this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, everything is back-end, so you don't even need client software. If you have a browser, you can use BitNext. Follow the link and give them a try. 28 days free of charge. You can't beat that with a stick. Now, back to the main event. Thomas acknowledges that the right to keep and bear arms does not necessarily mean the right to carry anything, anywhere. Certain sensitive places have always existed where one may not carry weapons, including in school or in a government building, like the courthouse. But the gun-free school zone might be something new. Thomas notes that no one has ever disputed whether it is lawful to keep guns out of schools and buildings and so on, although he might or might not know about the decision in Utah to let concealed carry holders carry their weapons even into a school. Tellingly, untoward incidents have been few, far between, and nothing as tragic as the recent Uvalde incident in Texas. But the New York respondents made a problem for themselves. They tried to define a gigantic, sensitive place to include all public areas where law enforcement is generally available. Here's how Thomas puts paid to that respondent's argument. He says, respondent's argument would in effect exempt cities from the Second Amendment. Touche, Mr. Justice Thomas. Touche. Besides, available law enforcement almost never responds to prevent crime. Only a magical thinker would suppose that the very availability of law enforcement would be enough of a defense. Furthermore, Thomas rejects the notion that all but the specially privileged or targeted are too dangerous to trust with guns. He finds no support for that in history, and in any event comes down subtly on concepts like privileges and immunities of citizens, due process of law, and incorporation of certain rights that every state must respect. Thomas' most devastating historical analysis concerns Reconstruction, and even the time shortly before the outbreak of the war between the states. Ironically, the infamous Dred Scott decision recognized a general right to public carry from the Second Amendment. Chief Justice Roger B. Taney sought to deny black citizenship and all the privileges and immunities that go with it. One of these is the right to carry a gun in public in self-defense. More tellingly, Thomas describes how blacks routinely and often on advice carried firearms for their own defense during Reconstruction. Indeed, he mentions a freedmen's school in Maryland where pupils went to school armed, and the teacher carried a revolver. Bear this in mind when the debate about gun-free schools or school zones starts up again. Now, did this mean absolutely anyone could carry? No, but someone had to show that he was dangerous to lose his right to carry. Moving forward, Thomas criticizes the respondents for citing several Western territorial gun laws. The problem for the respondents is that few of these laws came under scrutiny while the territories existed. And after those territories became states, those gun laws fell by the wayside. And as for a few state gun laws respondents cite, Thomas politely says they would not withstand court scrutiny today. Now, let's be clear. This decision does not necessarily allow any and all kinds of weapons. Justice Kavanaugh points that out in his own opinion. But it does allow someone to carry the sort of weapon in common use. That is, in common use today. So perhaps it will remain for another case, or a campaign for a repeal of certain laws to restore recognition of the right of any lawful resident to arm himself at least as well as, if not better than, an infantryman. The 2022 Texas Republican platform, in fact, calls for the specific repeal of the foundations of federal gun control law, which are National Firearms Act of 1934, Gun Control Act of 1968. However, Thomas in a footnote, specifically warns that even the 43 shall issue states might face constitutional scrutiny in certain circumstances. Because any permitting scheme can be put to abusive ends, Thomas reserves the court's authority to intervene if, for example, the permitting authority is too slow to process an application, or the permitting authority charges a fee that only the well-heeled or the well-connected can afford. Now, Justice Stephen G. Breyer gives the dissent, and when I read it, I wondered whether Justice Breyer even thinks we ought to have a Second Amendment. Newsflash, Mr. Justice Breyer, a new sheriff came to town and installed 2 new deputies. You know who they are. Well, 3, but one of them replaced an equally good deputy who had died. But I digress. As Thomas rather archly observed, Breyer did not even lead with any historical analysis. Instead, he starts with a litany of statistics on mass public shootings, suicides, and domestic violence. In other words, Breyer is saying, it's not safe to let just any average Joe carry a gun in public. Thomas destroys that argument with one quote from the McDonald case. The right to keep and bear arms is not the only constitutional right that has controversial public safety implications. Close quote. Besides, Thomas consistently shows that constitutional rights do not depend on the implications of the moment. He does not practice situational jurisprudence, which is like situational ethics. Justice Alito comes down even harder on Breyer's dissent in his concurring opinion. In sum, he says the New York law didn't stop the Buffalo shooter, wouldn't stop a suicide, and wouldn't be relevant to the domestic violence cases anyway, because they don't happen in public. Justice Kavanaugh's concurring opinion pointed out that this decision leaves the shall issue state laws alone. Here he sets forth the kind of requirements a shall issue state may make. Quote, those shall issue regimes may require a licensed applicant to undergo fingerprinting, a background check, a mental health records check, and training in firearms handling and in laws regarding the use of force, among other possible requirements. Unquote, Justice Kavanaugh. Justice Barrett wrote a 2-page concurrence on the proper and improper use of history. Now then, I looked around and found 5 mainstream media examples for reportage. Reuters, CBS, CNN, NPR, and the Beeb. The CNN link turned out to be a live updates link that refreshes itself with new information or reaction. In general, these reports quote the usual suspects, but NPR is good enough to cite an opinion contrary to the breathless alarm by New York City Mayor Eric Adams. Specifically, Professor Glenn Reynolds of the University of Tennessee Law School said, and I quote, I heard Eric Adams say that now is going to be the Wild West in New York. And I'm like, yeah, you're going to have what? Running gun battles in the streets and on the subway? Oh wait, you already have that! Unquote, Professor Reynolds. Did you love it? His Honor did use the phrase Wild Wild West and talked about an additional river feeding the sea of gun violence. Acting Governor Kathy Hochul called it reckless, reprehensible, absolutely shocking. She even said, and I quote, the insanity of the gun culture has now possessed everyone all the way up to even the Supreme Court. Can you believe that, gal? President Biden said the ruling contradicts both common sense and the Constitution. Yeah, well, hey, Biden shows little respect for the Constitution himself. And as to common sense, to him, that means that only the officially trusted should even touch a gun. Justice Kavanaugh, in his concurrence, suggested that the 6 may-issue states and the District of Columbia become shall-issue states instead. They might have to. The court now seems determined to interpret the Constitution according to its original meaning. The days of the Supreme Court regarding the Constitution as a living document are over. But what exactly happens next? Will New York City and state double down on enforcement of their law? How will other states react? What will it take to impress on people that courts may no longer change the meaning of words? And what will happen to the Senate gun deal that is likely to pass the Senate? And then the House. Will we next see a direct challenge to that law the instant the president signs it? Stay tuned. Links to the description of the article, to the opinion, to the PolitiFact article listing 25 constitutional carry states and the conservative news and views. I have another link to the awesome online store and to BitNext, as I also mentioned. And if you like what you've heard, you can like this video. And check out the subscribe link and my new playlist of all things Second Amendment. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.